And so here we go. Estate planning. What the heck is it? Why does it matter? Of course, you've heard this before, I'm sure, that you don't want to die without having your things in order because then what? Then the state gets to decide, pardon me, the state gets to decide what happens to all your stuff. But when I talk to people, there's common myths floating around like it's only for old rich people, or I'm just too young to think about it right now. Or maybe you think the process takes way too long or it's way too expensive because we all know lawyers charge a lot, right? Or maybe you've already set up a will and you think that you're all set. Well, don't leave your most important life decisions to the state, okay? Even if you have a will, that will has to go through the probate process. And unless you set things up correctly, then somebody else who you don't know and they probably don't care too much about you because they don't know you, they're going to make your decisions. That would be bad. And it's a really big issue. I mean, 63% of Americans don't have a will or a trust. And only 8% have, or I'm sorry, 8% out of those have out of date documents. So it's not something you want to set up and just ignore. You want to take a look because laws change, situations change, and so on. Couple examples of people who got it wrong or where things went wrong. And Michael Jackson, obviously, you know him. He had a team of lawyers, right? Just imagine what kind of lawyers that money would buy. And his estate plan, though, was filled with mistakes. So he had an estate plan, but no one was working on that plan. They didn't put any of his property into the trust. Now, maybe they were taking some of the drugs that he was accused of taking, because that just seems pretty basic, right? But because his assets were not in trust, which triggered probate, and then freezing of his assets and delaying the distribution of his estate, not to mention the immense cost. And how about Robin Williams? I mean, he had an estate plan, but it didn't include a contest provision, which would have stated that anyone who contested the will would risk his or her entire inheritance. The result was an estate that got hung up in litigation, due to lawsuits. In other words, to make it simple, people are going to fight over your stuff after you're gone, right? And another big mistake is not updating your beneficiaries following big life changes. And that can be a big mess. Okay, so let's say that God forbid your husband passes unexpectedly. Well, if you have your life insurance policies, for example, or anything with a beneficiary, what I've seen go wrong is where people are married, then they get divorced, and they don't go back and change all their beneficiaries. So you can end up passing away and leaving all your stuff to the wrong person simply because you didn't go through and keep an eye on these things. So, what you don't want to assume or think is that you get a will and it's a once and done type of thing. You really need to review it every few years. Okay, so this is not going to be a real long meeting. There's only 20 slides here, and I'm going to just run through some basics. So, what is estate planning? What's essential? What essential documents do you need? How about a revocable living trust? We're going to touch on estate taxes and probate, and your estate plan. I'll show you an easy way to kind of get something going for yourself at very low cost. Okay, so what is estate planning? Well, it's a way to make sure that your assets are distributed according to your wishes after you die or become incapacitated, and that your loved ones won't have to face complications or conflicts. So, doing this kind of planning kind of confirms that you love your family because you won't be here, right? So, it's all about taking care of them. And you can see the check marks here. There's a couple documents that are in play when you deal with setting these things up correctly. Okay, so what are some essential documents? Well, first of all, powers of attorney. You have a financial power of attorney and also a healthcare or living will power of attorney. So, first, the financial power of attorney, what that does is give your agent, whoever you dictate, right? So, if I set up my cousin or whoever, then that person is considered the agent. They're going to have full legal authority to manage my financial decision or affairs and all assets not owned by your revocable living trust. So if you set up a revocable living trust, then you have somebody else who has the authority to manage the assets owned by the trust. So if you don't have a trust, then you still need somebody to have legal authority to manage your finances if you're not able to. So the situation you would need this is when something unthinkable happened that would prevent you from making your own financial choices. And that's why you need this financial power of attorney because it gives your agent the power to make those decisions for you, whether it's due to an accident or a sudden illness. The last thing you want is for your long term financial future to be at risk because of hopefully a temporary setback. But with a financial power of attorney, your agent can keep everything moving smoothly with your money. And so this is one of the documents that I am covering the cost for you attending or for you viewing this webinar because I believe that this is such an important thing you need to do that I don't want you to think money is the reason or the blocker that you can't get it done. Right. So that is your financial power of attorney. Pardon me. Okay. So now we have, hang on a sec, trying to get my slides to play nicely. Hmm. I think one of my slide pages disappeared. That's odd. I'll have to circle back and find out what happened to that. This should have stuff on it about the healthcare power of attorney. But essentially, it's the same thing. The healthcare power of attorney is when you are incapacitated or have an issue and you need somebody to make the healthcare decisions for you. So equally as important to the financial one, but for different reasons. Well, how about a will and testament? What is a last will and testament? Okay, so last will and testament is a legal document that communicates a person's final wishes pertaining to assets and dependents. So your stuff and your kids and family and who gets what. That's what this thing is going to outline is what exactly to do with your possessions and whether you are leaving them to charity and what happens to other things that you're responsible for. If you have any dependents or other financial interests, you're going to spell out basically all those things. So a revocable living trust or revocable, depending on how cool you want to sound when you're saying this, it's also known as an inter vivos trust. And that's just a Latin word that says it means between the living, indicating that your trust was created during your lifetime. Revocable means that the trust cannot be or it can be changed. I'm sorry, there's an irrevocable and that popped in my head for a second, but revocable means that the trust can be changed or revoked during your lifetime. And again, this is the basics. There's a whole lot more detail to this, and I'll save that for an enhanced planning webinar. But this is just to kind of get you going on the basics. So your revocable trust can be changed or revoked. And what it does is it creates a legal entity to which you then transfer ownership of your assets into. And it empowers you to manage your assets during your lifetime and contains the details for how your assets are to be distributed at your death. So, why would you want to have a revocable living trust? Well, it's going to allow you to avoid probate proceedings that would be required if you only had the will. So, probate is basically the process of getting rid of your stuff after you die. All right. So when you have a will, that's basically a ticket to probate. That will, you listed out how you'd like things to go, and then somebody has to go through and make sure all that stuff happens. Well, that's the probate process, and it can cost time and money. So when you die and you have that revocable trust, then when you die, your successor's trustee is then the trustee is the person in charge, right? They are empowered to manage or distribute your assets without the need of a court order. So you can kind of skip over the court process altogether with a revocable living trust. And in addition, assuming that nobody contests your estate, as soon as all your outstanding tax bills and matters are resolved and creditors are paid, then the assets can then be distributed to your beneficiaries. So there's really several benefits to the revocable trust, and that's the big one, right? Avoid probate, save time and money, and keep things private. Okay, so let's take a little bit closer look at that. There's really three key people in the revocable living trust situation. First, you have the grantor, and that is the person who creates the living trust and decides what property to include and who the beneficiaries will be. So, let's say that's me. I want to set this up to make sure I can get rid of my stuff. Then you have the trustee. That's the person who manages the living trust. So that can also be me, right? So I can be the grantor. I can say, hey, I'm going to set this up. And because it's revocable, I can still manage things while I'm alive. The successor trustee manages the trust after you are gone. Then they take over management. And of course, just like on a life insurance policy or an IRA, you can write in a beneficiary. And this is the person who receives benefits from the living trust. So, what kind of benefits? Again, avoiding probate, huge. Generally considered more difficult to attack in court and provides privacy. I don't know about you, but I'm a kind of a private person to a certain degree. And, I'd much rather have things be easy for my beneficiaries when I go. And obviously, saving time and money is always huge. Um, so, it's just kind of a sensible thing to set up. Okay. So, probate, I used the word a couple times. What is it? It's a legal procedure where assets are formally passed to the beneficiaries. It takes time. It can be expensive. Some estimates are 10 to 15% of your whole estate. So imagine you want to pass on all this money and things to your kids, and the state and attorneys can come in and just swoop out 10 or 15%. Lots of fun, right? I'm sure that's why you go to work every day, is to plan for the state to take your stuff or to make it harder to get your stuff there, right? So you get these delays, and the best part though is it's completely avoidable. Like right now, if you got some life insurance, you write a beneficiary on there. Guess who that money's going to go directly to when you die? The beneficiary. So even if you have a relatively simple estate, probate can eat up time and resources, and it can cause a ton of stress in the months or even years that it could take to settle an estate if it's more complicated. So think about this. You just lost a loved one, and now you have to sit there with meetings with attorneys and court proceedings for months, potentially. And it's all publicly because the probate process is a public proceeding. So just imagine how that would feel, right? I mean, you're trying to grieve the loss, and now you've got to deal with all this legal mumbo jumbo. Uh, and then, the cost of doing all that. So not only do you get the fun of the stress of, you know, losing your loved one, but now you got to figure out, you got to watch some of your money that you were supposed to inherit disappear. And again, it's completely avoidable. So living trusts were invented so that people can make an end run around probate. Just go right around it. So the advantage of holding your property in that trust is after your death, the trust property is not part of your probate estate. It is, however, counted as part of your estate for federal estate tax purposes. It's a little bit different conversation, a little more detail there. We can get into that another time. But, after your death, basically, because the trustee, not you as a person, the trust owns the property, right? After your death, the trustee can easily and quickly transfer the trust property to family or friends you left it to without probate. So you specify in the trust document, which is similar to a will, who and who you want to have inherit that property. And I don't do trust here. I'm not an attorney. Full disclaimers. I'm just, you know, as a fiduciary financial planner, what good would I be if I didn't help you at least figure this stuff out? So, what documents do you need? Well, we're on slide 17, by the way, only a few left. So, what documents do you need? First of all, power of attorney, like we mentioned. You need financial and healthcare power of attorney. It can be anybody over 18 who you can appoint. And again, I'm going to cover the cost of the financial and healthcare powers of attorney. Why am I doing that? Well, because I'm hoping that when I lead with value like this, you're going to get interested in what else I do. And B, if you do hire me to do some financial planning or what have you, well, then part of what I'll do each year or every few years is help you review, your estate plan and keep things up to date, just like I do with your financial planning. Well, did your expenses change? Or, what do you want? A new car? Oh, you're going on vacation. Oh, you need to build a deck. Okay. Same deal. We just add it to the list and kind of run through and make sure everything is going the way it should. But hey, if you never work with me, that's okay. I'll still help you get the financial and healthcare power of attorneys. And, if you want more planning than that, then I have an easy, low cost way to work with a network of attorneys. I'll show you in just a minute. But anyway, you need powers of attorney. Somebody making the financial decisions if you can't do it, somebody making the healthcare decisions. Um, and then the last will and testament. So you basically want to set up a will, okay, and especially because you still have to lay out how you want things to go. So I know it sounds like a trust is, oh, I need a trust and the will's no good. No, you still have to have that will to kind of spell things out. But it's a matter of where do you put the property after that. So a revocable living trust can be great for people who own real estate, for example. Again, we're just scraping the surface here. So let me get you familiar with some of the essential language, just so you can kind of see what some of this means. So you want to make sure that in the living trust, and again, this is what an attorney will help you set up. But what about qualifying for Medicare and Medicaid? What if you have digital assets? Is there a contest clause? Okay, because that can determine whether or not your things can be contested. I mean, I could look at the paper and say that you died, right? And say, oh, well, so-and-so owes me money. Well, it might not be a valid claim, but it has to be investigated. It takes time and money. There's a couple other things. Sprinkling provisions, ability to modify trust status, avoid minimum distribution penalties on qualified plan assets. You know what I hear is blah, 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 blah. I need somebody smarter than me to kind of make sure that all of this is taken care of, right? Okay, so to make this really simple for you, everybody has an estate plan. You have an estate plan right now. Whether you chose it or not is the difference. Okay, let's say you didn't do a will, you don't have a trust, none of it. Well, the state then is going to decide what to do with your stuff. And if you're cool with how the state of Maryland decides what to do with your stuff, well, then cool. But I'll tell you what, I'm not cool with. Definitely not cool with the state of Maryland deciding what to do with my stuff, you know, because they're going to make the wrong decision. But look, keep it simple. All you need to do is plan as if you're going to die right now. Just put yourself in that situation. Lots of fun, right? Hey, honey, you want to pretend we're dead? Uh, but it really is that simple. I mean, you just go, okay, I passed away. Now what? You know, ask your wife. Now what? What do you do? And Lynn knows when I die, she knows where to go, how to get into my computer, where all my bookmarks are to all the financial assets, our bank accounts, those types of things. And you have to understand this is a process, not an event, because things change, right? You get a new bank account, new grandkids, laws change. So just like we review your Medicare, your Part D drug plan every year, your life insurance every year, your long-term care plan, your financial plan, your income, right? If you don't have a written income plan, then you're kind of just guessing and hoping you hit your goal. Same here. You want to make sure that you get this done. Now, look, here's the easiest way that I found to do this. Okay. I use a tool, or I bought into a platform of a network of attorneys who developed a digital process that you can just kind of go online and answer some questions, and it walks you right through basically what you need. Will spit out the other end, right? So the attorneys, if they think you need a trust based on what you answer, then they'll spit that out in the output for you. You don't have to sign up, but if you do, you're not paying me, you're paying the attorneys directly. Okay, and I'll help you get started by giving you the financial and healthcare powers of attorney. But I'm going through the process myself because I believe practice what you preach, and I do like the online system. It's really pretty easy. Again, if you're working with me, you want to hire me to do some financial planning, I can help you set this all up. But I think you'll really like it because it's easy to use. It's intuitive. The documents are all legally sound. They're not just, there's real attorneys across the country making sure all this stuff is up to date. It is 100% attorney guided. It's easy to update when life changes. You can actually give access to somebody else. You can share your plan. And this is huge because, I run into this every single day where I'm helping somebody do anything. And it takes us an hour to work through the technical issues that most of you are experiencing, right? You don't know how to do all this tech stuff, but guess what? That's the world. And you know who does know how to do the tech stuff? Your kids and your grandkids. So you can add your kid, your grandkid right on there onto this software tool and give them access. It's awesome. The estate plans are customized to your answers. They will ship out an actual binder with your documents in there, and you can skip all the traditional lawyer fees. Now, look, I'm not saying that advanced planning you have to eliminate attorneys. There's nothing wrong with that, but a lot of times, do you really need $8,000? Do you really need to pay someone $300 an hour to come up with a will? No. Now, that's what I've covered the cost of this network, so I could bring low-cost legal documents to you. So that's it. I don't want to keep you here all day. That was about 25 minutes. If you have questions, I'm not doing a live format because I'm kind of just getting used to this live broadcasting on YouTube. But if you have questions, give me a call. Actually, you can call 443-543-9200 and just talk with Morgan. She is my artificial intelligence virtual assistant, and she will chat with you and help you book an appointment right onto my calendar in the next open spot. or just leave a message. Either way, I will monitor that and get back to you, and I'll help you get these documents that I promised. Um, that's about it. So thanks for listening, and let me see if I can figure out how to end this deal. All right. Hey, thanks. Take care.